immigration question.
All right, let's go to Aisha in Lake Worth, Florida. Aisha.
Okay, I have a question, an immigration question. So I am a U.S. citizen, and I plan on bringing my mother and two of my half siblings here. One of my siblings will be turning 21 soon in like 2 years. I want to know, would I be able to file for all three of them at the same time?
For all of your siblings, you can, but
Well, for my mother and my siblings.
yes, but they're not all going to get their green cards at the same time. So those are two different things. The answer is yes, you can file an I-130 for your mother. No, yes. In question on the I-130 is name your mother's children, which would be your siblings, but that does not include them, unfortunately, on the application. You're just answering a question. What's the name of her children? You would have to file separate applications for your siblings. They would be in a separate category. Your mother would be here as an immediate relative in about a year and change, maybe less. And your siblings would be here based on your application for them in about 12 years, 13 years, 14 years, 15 years, over a decade, whatever it may be. If as long as they're single, whether under 21 and over 21, the faster route would be file for your mother, let your mother come up with her green card, and then your mother turns around immediately, the day she arrives in America, even if her green card's not mailed to her, and files I-130 visa petitions for your siblings. If they're under 21, they'll wait 2 more years to come up. If they're over 21, about 5 or 6 years. That's faster than you filing for them.
Okay, thank you so much.
And by the way, if you're like, well, that still doesn't work in my life, I need to figure out a way to get these kids here, my brothers and sisters here faster, you probably need a consultation. We'll see what we can do, how we can figure it out.
I would need a what?
A consultation. I don't have an answer on how to get them here faster off the top of my head.
Okay.
All right?
Okay, sounds good.
Okay. Let's go to Sammy in Baltimore. Sammy.
Yeah, good evening, Brad.
How are you?
I'm okay. I have a question concerning my case. I have a VAWA case which I've been pending for like 15 months now. I filed on May 2019. So up to now, I have not been able to receive a prima facie or anything except I keep on renewing my work permit because I have a pending I-485. But recently, my wife withdrew the I-485, so they denied it. So I have to file for another I-485 for the VAWA, although I have not received the work permit, which is pending for almost 4 months now, 4 months and a half. So I'm just thinking of looking for an alternative, you know.
Well, let me say this, okay? Number one, if you didn't get a prima facie, it's not a positive outlook on your case because you didn't even show the bare minimum that you're in a bona fide marriage and you were an abused spouse. Number two, when you filed the I-360, you need to notify immigration that you want to convert your adjustment from an I-130 case to an I-360 case because one hand doesn't know the other hand. And until you do that, your wife controls the I-45 who was abusing you, and now she's abusing you more by withdrawing it. So yes, you would have to file a new adjustment application. VAWA cases take over 2 years, so it's not surprising that you haven't heard anything yet.
Okay.
So, and then your question is, what else can I do? I don't know. You would have to have a consultation. I can't solve your life in a 2-minute telephone call on a live show. So hold on 1 second. Let's go to Abe in Houston. Abe. Abe.
Hello?
Hi, Abe.
Hey, how are you doing, sir?
Good. What's going on?
Hello?
Abe, I'm listening to you. What's going on?
Oh, yeah. I have a question right concerning the immigration.
Go ahead.
Oh, yeah. My question is that, firstly, I'm married American citizen, and that is like some years ago, but we are no more together, and we divorced, right? So, and I'm married again, American citizen. So, and I want to put my paper in. And the lawyer that I used, he helped me pull the last information out. But when the lawyer put the information out, they saw it that they're about telling me to leave the country.
All right,
Because
Abe,
we did not
all right,
receive,
Abe,
I did
Abe,
not receive any letter from them.
Abe, you were married. The case didn't work out. Immigration put you in deportation, or they just gave you a letter saying leave the country? What's yes? That was an either or.
Yeah,
Are you in deportation? Were you ordered deported, or you have a letter just from immigration that says please leave the country? Do you have a notice that was a notice to appear where you put in removal? Did an immigration judge say you didn't show up to a hearing and we're ordering you deported? Is that what happened?
Yeah, but because we did not receive any letter.
Okay, so if you got so Abe, what that is, it's called a deportation or removal order in absentia, which means you never showed up to the hearing. Now, you're saying to me you never got notice of that hearing. All right, because and as part of a fair hearing, even in immigration, you have to have a fair hearing. They have to give you proper notice of your hearing. They have to tell you when and where you have to show up to defend yourself in a deportation removal hearing. And if they don't tell you properly, let me just finish my words and then you can say whatever you'd like. And if they don't tell you properly and fairly when and where to show up, it's not very fair to you because you weren't there to defend yourself. It's like a kangaroo court. You know, they find you guilty and they never told you to show up to defend yourself. So that is called a due process violation. Due process means they have to follow a fair procedure in order to effectuate your deportation. That's what due process means, fair procedure. It's not very fair if they don't tell you when and where to show up. So as long as I can prove as your lawyer, if I'm your lawyer or whoever your lawyer is, as long as they can prove that you were not given a fair chance to show up to your hearing to defend yourself because they never told you where to go, they never told you when to go, maybe they did but they mailed it to the wrong address, or maybe they never mailed anything to you, then you have a right under the United States Constitution to reopen your deportation case. When you reopen your deportation case, that is not, I won my deportation case and let me shuffle out of court. What a reopening case means is, I want a do-over. I want an opportunity to have a fair hearing. So when you reopen your case, you don't win your case, you get a do-over. We start from the beginning again. So now, if you reopen your case and we start from the beginning again, and you're now remarried to a United States citizen spouse in a bona fide loving marriage, in this do-over case, we go into court and say, hey, don't deport this guy. He's in a bona fide marriage. Let us prove that as well. And that would be the process. And ultimately, if we're able to do all of that, you would adjust your status before a judge. So it all starts with proving you were given an unfair hearing. You weren't told when and where to show up. So hold on one second and let's see how we can fix all this for you. Let's go to Suresh in Monroe, New Jersey. Suresh.
Hi, Uncle Brad. I had a VAWA-based 10 years green card. Last year, my removal proceedings was terminated and the I-589 application was closed. And the UIR has the same information that the terminated case or something like that. When I travel to home country, is it going to be a problem?
You got your green card through VAWA?
Yes, VAWA.
And you have a stamp in your passport, an I-551 stamp or a green card in your hand?
I had just a copy of the green card, no stamping in the passport.
All right. So as long as you have, you will need, if you're going to travel, as long as you're a lawful resident, yes, you can travel to your home country and back. That's not a problem because you're no longer in deportation. Just need proof of lawful residence. A copy is not going to do it. So either the original green card or you have to go down to your local office and get a stamp in your passport to travel back and forth with a temporary green card. But it's not a problem to travel. You're out of deportation. You have a green card.
And can I sponsor my new wife?
Yes, you can. When did you get married?
I'm about to get married.
Oh, you're about to. Okay, then yes. The answer is yes. I just wanted to make sure you didn't get married before you got
So
approved
I
for your
can take
green
the info pass appointment. I can go to the
Absolutely.
federal building for the stamping.
card. Absolutely.
Okay, thank you so much, sir.
But when you go, they're not going to stamp your passport unless you bring a plane ticket. So bring a plane ticket.
What is that?
Bring a plane ticket. They're not going to stamp your passport unless you bring a plane ticket.
Okay.
All right?
Yeah.
Okay.
Thank you, sir.
All right, let's go to Devin in Miami. Devin,
Hey, Brad. Thank you for taking my call.
how you doing?
I just have a good, doing well. Just a quick question I have based on I filed a 485 for my wife. I went 3485 back in March of 2019. November 2019, we got an interview. Before the interview canceled. So now we've still been pending, waiting about 17 months now. Trying to figure out, if there's any other steps that I can take.
Yep.
To get some information. What's happening? We sent service requests. We had Congress involved, and they keep sending the same generic information. Oh, we're actively reviewing the case. We'll give you make a decision when they come to that decision.
Right. So you never had an interview yet with your spouse?
No interview.
Right.
They scheduled it. It was canceled.
Right. The only good news out of all of this is that I'm sure you've been married now for more than 2 years. So when your spouse does get a interview, she'll get a permanent green card. She won't get a 2-year green card. Probably.
We've been married like 6 years now. Yeah.
So you got two choices, okay? Which is do some combination of everything you're doing, which is do nothing or call the immigration for service requests or go to your congressman or senator. And what you found out from doing all of this is, you're just spinning your wheel in circles and nothing is happening.
Exactly.
The only thing you can do that works in situations where immigration is delaying your case unreasonably. And unreasonableness to me, when you're an immediate relative, which means that your wife is immediately eligible for a green card. There is no waiting time. So to me, in my opinion, it is unreasonable to have a law that says that if you marry a U.S. citizen, you're immediately eligible for a green card, and then more than 12 months goes and they don't even interview you yet. To me, that's not immediate anymore. That is delay. Whether delay on purpose, whether delay because of negligence, who cares? It doesn't matter why they're doing it. It's delay. It's a violation of your and your wife's rights to immediately get a green card and certainly be interviewed for that green card.
Yeah.
So what you do, the only thing you can do is demand that your rights be given to you. And how do you demand that your rights be given to you? You go into federal court and you say to a federal judge, I filed this application 18 months ago. I demand to have an interview. I should have had it more than 6 months ago, 8 months ago. If it's more than 12 months, that's unreasonable at this point. It's called a mandamus. I say it all the time. Now, you may say, wait a second. I don't want to screw with the federal government. I don't want to sue them in a mandamus. I want my wife to get a green card. They're going to be really pissed off at me. And if they're pissed off at me, they're going to deny the case, not approve it. Well, I'll say two things. Okay, with that, because I'm sure that's what you're thinking. Okay, number one, in most cases we like to do, this is what my office calls it, everybody calls it something different, but we call it what's called a pre-litigation mandamus. There's no real legal term for it, but we call it the pre-litigation mandamus in my office. And what the pre-litigation mandamus is we put a lawsuit together and we send it to the head of the litigation unit in that particular city. And we say, dear sir or madam, here's this lawsuit. It's a mandamus. You want to meet us in federal court and get yelled at by a federal judge and waste your time and effort, or you want to just schedule them for a visa appointment. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.